All right. AG, let's start this morning with your initial reaction to the news that came out last night.
Thanks, Lindsay. So, firstly, obviously, when this broke yesterday, unprecedented for a decision to be released before finalized. So that's something that in my career I've never seen before. Normally, the court is so tight-lipped that you never even have an inkling as to what the court is going to do or what the decision is going to be until literally the very second that it's released. But that being the case, it appears as though the United States Supreme Court has confirmed that this is authentic, what Politico actually released last night. And I will say it's surprising that it leaked, but the decision in and of itself is not a surprise, nor should it be a surprise to anyone. I remember vividly being at the first Women's March in Michigan in January of 2017, and I gave a speech at that event. So did Governor Whitmer, so did many other people who either were then or are now in elected office in Michigan. And said that plainly with Trump about to take office and knowing that he had a very significant litmus test in order to make the short list for nominees, we had a situation at that time, you might recall, where Scalia's seat had gone unfilled. And so that was going to be a seat that he was going to be able to fill it immediately, since he then had the Senate was majority Republican. And knowing that there were three other justices that were in their 80s at that time, Stephen Breyer, Justice Kennedy, Justice Ginsburg, and that we were likely to see a dynamic shift in the court, and that those new justices who would become members of the court during the course of the Trump administration were certain to add the necessary votes to overturn Roe v. Wade entirely. And so with the swearing in of Justice Kavanaugh, they then had a majority of justices who believed that Roe v. Wade was wrongly decided. And then when you added Amy Coney Barrett after that, now you had basically a supermajority of justices. So it was clear, irrespective of which way Roberts was going to go on this, that you were going to have a majority of justices that could overturn Roe. That being the case, it seemed inevitable that it would happen this year. And why? Because, of course, the Dobbs case, that was a specific request that was being made by many of the states, certainly by Mississippi, but then in addition to that, many other states that filed a mickey on their behalf. And then we saw that there was no action taken to stop the Texas law from being enacted, which is a very draconian law that outlawed abortion in the state of Texas, and even weirdly allowed anyone to have standing to be able to sue someone who in any way, shape, or form participated in an abortion. So for all intents and purposes, no abortions permitted in the state of Texas. So it seemed very clear that since they didn't even stay that case, that they were headed in this direction. So while it's a surprise that it's leaked in the manner that it has, the result is not a surprise. The only difference is that this is not official today, and it won't be official until it is formally released by the court, and that's generally expected to be in mid to late June, towards the end of their session year. But with that being the case, I sort of expect this to be expedited at this point. I'm sure they're not going to want just this hanging around. So I imagine it'll come out earlier than was otherwise expected. I'm sure some of you are wondering, well, could this change? And could we see something different? Theoretically, of course, that's true. It's not a final version. We don't know exactly where the votes are. We only know that this case was assigned to be authored by Justice Alito because he was in the majority, meaning there were at least 5 votes to completely overturn Roe v. Wade. And so whether or not those numbers are going to change, I think it's evident that we will see the formal and express overturning of the 1973 seminal Supreme Court decision that legalized abortion nationwide in Michigan. Now, what will that mean for us here in Michigan? Well, it's very simple. All of these issues will be thrown back to the states. So it will be incumbent upon each and every individual state to make the decision as to what is legal and what is not legal in regard to the matter of abortion. So what will happen in Michigan? Well, Michigan is one of these states that has what we call a trigger law, and that law is MCL 750.14. And what that means is that abortion is not just illegal, it's a crime. It's not just something that someone can sue over civilly. People can go to jail or prison for this. And I'm just going to go ahead and I'm going to read MCL 750.14 so everyone knows and understands the language. It indicates that, well, I guess I don't have the entire thing, but it has any person who willfully administers any pregnant woman, any medicine, drug, substance, or thing whatever, or employ any instrument or other means whatever, with intent thereby to procure the miscarriage of any such woman, unless the same shall have been necessary to preserve the life of such woman. And then the language goes on. And so it is a felony offense. Because there's not a specified penalty, there is another statute that for those types of offenses that aren't otherwise specifically, there's not a specific connotation for a penalty. It's a 4-year felony offense, meaning a person can go to the Michigan Department of Corrections for up to 4 years in prison for that. Now, in terms of who gets prosecuted, basically, there has been case law developed, basically indicating that it is, a physician or whoever the person is that performs the procedure. And generally speaking, the way that it's operated prior to Roe, and remember when Roe came into being in 1973, it superseded this law. It rendered it unenforceable. It was never removed from the books. It was never repealed, which is why it still exists, but it just couldn't be enforced anymore because of Roe v. Wade. And when, it's not if now, but when Roe v. Wade falls on whatever day this is formally released by the United States Supreme Court, MCL 750.14 will spring back into effect. And so what does that mean? It means that prosecutors in all 83 counties could prosecute the criminal offense of abortion. They could prosecute a person who performs an abortion. And I think the plain language of this, which again, it's a 1931 law, I would argue that it's possible for a prosecutor to interpret this as to actually prosecute a woman who is attempting to self-abort if she is the one who performs the procedure or she's the one who takes the medication. And of course, things have changed since 1931. Many women use abortion medication in order to have abortions. So I do think that one could argue via the plain language of the law that if you're the one procuring the medication and you're the one who is administering the medication, that the woman herself could potentially be prosecuted. Again, that's not what was traditionally done, but what we did see happen a lot is that you would have a prosecution against a physician or some other medical provider or even a third party who wasn't a medical provider who would perform the abortion pre-Roe. And then if the woman who had the abortion refused to cooperate, she could be held in contempt of court. So you did see cases where women were being held in jail either because they refused to testify or they didn't show up when they were subpoenaed. And so that has happened in Michigan before. Whether prosecutors who wish to enforce this law will enforce it in a manner where they're just prosecuting the person, a medical provider, for instance, or they choose to prosecute women who have abortions, that'll that'll remain to be seen whether or not that can happen. And it also calls into question many other things, I will say, about this particular law. Firstly, will it create a scenario where if a woman has self-aborted and she seeks medical care after that, will the doctor, usually there's doctor-patient, confidentiality, but because this is a criminal offense, will the doctor then have to report that to law enforcement? And then there's other questions, right? Like if a woman goes out of state and procures abortion medication and brings it in state and then technically administers the medication to herself in Michigan, is there a charge there? Is somebody who brings in abortion medication into the state, can they be charged? I mean, these are all questions that I think people will have. There's no exception for rape. There is no exception for incest. There is a provision that says, again, unless same shall have been necessary to preserve the life of such woman. But the way that this is drafted, my opinion is that that's an affirmative defense for a physician. So for instance, what I see happening is for prosecutors that want to bring these cases, they could bring the case when they find out that there's been an abortion, and then it would be up to the doctor or the physician or whoever the abortion provider is to use as an affirmative defense, much like you would with a self-defense case. Yes, the abortion happened, and now now the burden shifts to the doctor or the physician or the abortion provider to say, yes, I performed the abortion. However, it was necessary to save the life of the mother. And then basically it could be a contest of experts, because you'll have to say, well, no, I mean, it's not just that this woman could have been seriously injured or harmed, or that there was some other medical emergency. You would have to actually show that the woman was going to die, or it would still be a crime. And that is really concerning to me. People have abortions for all kinds of reasons, and many of them are medically necessary. But I think that this will have the kind of chilling effect that doctors just simply will not perform this procedure really under any set of circumstances, because they don't want to get dragged into court. They don't want to face the possibility of being prosecuted and the possibility of going to jail or prison. So I think that honestly, even under very serious sets of circumstances, you'll have doctors that really have to violate their Hippocratic oaths and just, say, I'm sorry, I can't help you. I understand you have, for instance, an ectopic pregnancy, and it's there's no viable child, right? The embryo is not viable, will never become viable, will never be born alive. And the woman could die, but if we know that she might not, if it's only there's a possibility that she's going to die, well then, again, if you're that doctor, do you really want to take that chance and risk losing your medical license and risk going to prison? And of course, I think for a lot of people who are abortion providers, their insurance carriers will drop them. And I imagine that will be something that is asked right by the insurance carrier. Do you perform abortions? And if the answer is yes, I think a lot of insurance carriers are just going to say, well, then we're not going to insure you under those circumstances. So what I see happening is just basically not having any abortion providers at all in the state of Michigan. And my grave concern is that you are going to have women who are going to die for a number of different reasons. Either because they'll be so desperate that they will try to self-abort. And of course, we know that's a reason why many women pre-Roe were harmed or died from those procedures. You might have illegal third parties that are not certified to perform an abortion, who will start to perform these abortions underground again, and in an environment that's not safe, that's not sanitary, and where you have somebody who's not a medical professional, who's trained and knows what they're doing, and therefore could cause women to be severely harmed or die. There are just a litany of reasons why I believe that For somebody like myself, who believes it's my job to protect the health, safety, and well-being of the 2.2 million women of reproductive age in the state of Michigan, that I will not enforce this law because I think it will lead to further harm and further death of women in our state. And that is something that I made very clear when I ran for this office. I actually did a commercial, you could pull it up, in 2018, that was on social media, where I said I was not going to enforce this law when Roe was overturned, because again, you didn't have to have a magic crystal ball to see what was coming in the future. So I said, when that happens, I'm not going to enforce this law. And of course, now I've actually been sued by Planned Parenthood, and I believe what they're trying to get me to do is to stipulate to the fact that I'm not going to enforce this law. I've already said I'm not going to enforce the law, and nor will I defend the law. I said I wouldn't use the resources of my office to defend this law, which I believe to be unconstitutional, and which, of course, there is a lawsuit that the governor's filed where she's indicated that this law, she believes, is unconstitutional. In that case, as many of you know, she's brought that case against multiple county prosecutors to try to enjoin them from prosecuting MCL 750.14 once Roe v. Wade is overturned. And I know that she's requesting what we call certification of the question, which means that it would go immediately right to the Michigan Supreme Court, because her claims are made under state law, or really under the state constitution, and her claims are that under the Equal Protection Clause of the Michigan Constitution and the Due Process Clause of the Michigan Constitution, that 750.14 violates those and is therefore unconstitutional and should be stricken. So, that matter is pending. And, with that, I guess I can take any questions. We obviously also have, I should say, the ballot proposal that is out there right now, the Reproductive Freedom for All ballot proposal. My understanding is it needs 425,000 signatures by July 1st, after which time the legislature has 60 days to decide whether or not to pass it. Assuming that they're not going to pass it, it would then go on the November ballot. And if it passes, then 750.14 will be unenforceable again in Michigan, because we will have as a constitutional provision that these reproductive rights, including the right to abortion, and that would supersede this statute, 750.14. So that is possible. And again, it's also possible that in the governor's case, the Michigan Supreme Court could rule that this statute is unconstitutional. Otherwise, to repeal it, you would need to have, obviously, a majority of legislators both in the House and Senate. And then, the governor has indicated she would simply sign it. So it's a bare majority for that to be passed. It's not a constitutional provision. It's just a statute. It can be changed at any time if you had folks in the State House, State Senate, and the governor's office that were willing to do that. So I think that's all the preliminary stuff.
We'll start with Stella, and then Alex, and then Jim.
Hey, AG. Stella, you with Bridge, Michigan. And so I have a question about, you promising not to prosecute these cases. So the statute of limitations for a felony is 10 years, and that's longer than an AG's term. You've promised not to prosecute, but would that actually provide a sanctuary for those abortion providers? Would they actually want to perform an abortion if there's a possibility that, other county prosecutors or the future AG could still charge them? Thanks.
So it's a 6-year statute of limitations, not 10. But yeah, that's a good point that you make. So theoretically, what could happen is I could say I'm not going to be prosecuting these cases, and people could continue to perform abortions. Doctors could continue to perform abortions in counties where the county prosecutor has pledged not to bring a prosecutorial action. And then you could have, let's say my Republican opponent, Matthew DePerno, were to win at that point. He has pledged to strictly enforce the law. In fact, he's stated that he doesn't even believe there should be an exception to save the life of the mother. He's been very clear about that, which means to me that even in those cases where it might be a close call, whether or not the procedure is necessary for that he would bring those actions, and then the doctors would have, be left having to defend themselves. So I think that, as you noted, it probably will have a chilling effect, because even if I am reelected, I will only have a 4-year term. So certainly, even if this happened tomorrow, my successor could definitely bring those cases if they wish to. And let me talk a little bit more about something else before I answer more of your questions. The reason why it's so impactful who the Attorney General of the state is, it's not just because I could bring an action in all 83 counties, but it's because of the work that we do with LARA, and because of our ability to go into any county in the state, get subpoenas, get a search warrant, and actually go into a doctor's office and review patient files, which we sometimes have to do in cases where there's a complaint against a physician. And also we could look at the insurance billing and see, was there insurance billing for a procedure that is an abortive procedure? And so we do that in other cases. I'll just give you an example. If we have a case where there's an allegation that a doctor is, over-prescribing opioid medication, then we have in the past gone in, have, search warrants, subpoena information, and make that assessment. And as a result, we can bring cases before the Board of Medicine that are licensing actions, or, if it's a crime, and sometimes it is a crime depending on what the circumstances are, bring a criminal action. So because the state attorney general really has so much more in the way of resources and handles the licensing actions anyway, that's why it's so important who the attorney general is and what their philosophy is on whether or not they're going to aggressively enforce the law on this. And I will say this one more thing, and then I will entertain all your questions. But when I hear individuals say, well, you're lawless, you're not enforcing the law. The fact of the matter is there are laws on the books that are rarely enforced. The adultery law has been on the books for many, many, many decades. And it's still a crime. It's never been deemed to be unconstitutional, but it's very rare, if ever, that crime is enforced. And I will say, before I got to the Department of Attorney General, my predecessors, they didn't bring charges under the Ethnic Intimidation Act, but I do. They didn't bring charges under the Payroll Fraud Act, but I do. They didn't bring environmental prosecutions, which I do. So, every prosecutor has whatever their priorities are. And I thought it was important. For instance, I took money away from some of the marijuana prosecutions that had been ongoing from my predecessor, and I put it into our clergy abuse investigations, because I thought it was more important to prosecute sexual assault cases than marijuana cases. So every prosecutor in their own county and every attorney general has their own priorities, their own initiatives, and that's what they spend their time, energy, and also their limited resources on. For me, both from an ethical consideration, from the fact that I don't want to do anything that causes women to be seriously harmed or die, and that again, if I only have a limited amount of resources, this is not what I'm going to be utilizing the resources of the state on.
Alex?
Thank you, Attorney General, for having us. I'm doing a follow-up for us, doing a nationwide look at different states and the different privacy interest laws that they might have on the books that were overruled by Obergefell and Lawrence v. Texas. Michigan still has a 1931 law that outlaws sodomy. Is there some concern that conservative activists might move to enforce that or create litigation that would lead us down a path to having that enforced in Michigan when it doesn't often get brought up?
Yeah, so thank you for that question, Alex. I am very concerned about that, and I've been concerned about that because remember, there's this penumbra of privacy based decisions, right? The right to privacy. And so, for instance, in Michigan, we, as you noted, we still have sodomy laws on the books. And I think it's to be important for people to know the sodomy laws don't just involve same-sex couples, intimacy between same-sex couples. They also involve opposite-sex couples, and it basically regulates the kind of sexual acts you can engage in, even with your legal spouse. Your legal spouse, consensually, there are certain sex acts that you are not permitted to have. Now, as you noted, in 2003, in Lawrence v. Texas, that was overruled. But if the court decides, as it seems like it might in the future, that right to privacy does no longer exist under the United States Constitution, then again, that law would spring back into effect. Same thing with the ban on same-sex marriage, right? We have not only a statute that prohibits same-sex marriage in Michigan, but it's also a constitutional provision that was passed via the Michigan Marriage Amendment in 2004. And as a result, in the event Obergefell was overturned, which it really does seem as though the court is setting themselves up to say, these rights that were previously permitted and established through the 14th Amendment, the Equal Protection Clause, as it was applied to the states, once you start to attack the basis that Roe utilized, which was again, Equal Protection Clause for the 14th Amendment and the right to privacy, then I think all of those other building blocks also start to fall, which means that same-sex marriage would then again, immediately, if Obergefell were to be overturned, and I do see a challenge probably coming to that, then, again, same-sex marriage would become illegal in Michigan once again. I will note that another one of the particular cases that I think is in jeopardy is Griswold v. Connecticut, which is the 1965 case that, that prohibited states from banning birth control and contraception. And that was a case actually involving the use of contraception between married couples. It was a crime. It's not just that you couldn't sell it, you couldn't use it. It was a crime. And so I know that, for instance, my Republican opponent has also indicated he thinks that Griswold v. Connecticut was wrongly decided. Now, I'm not aware of any laws that are on the books in Michigan right now that indicate that that would spring back into effect and that birth control would become illegal. It would have to be passed by law in order for birth control to become illegal in Michigan. But all of those other laws that I mentioned, sodomy laws, same-sex marriage law, certainly I can see those being on the chopping block as well. I mean, because those decisions will likely be coming shortly. I could see the next year, the next session and the next session after that, probably trying to chip away at those and us seeing, some of those seminal cases also overturned. So yes, I'm very concerned.
Jim?
Good afternoon, Madam Attorney General. So given your public statement that you've doubled down on today, and we have 7 prosecutors on record saying that they won't enforce the 1931 law, are you sending the message to doctors and healthcare providers to keep performing abortions, that they don't have anything to worry about in those 7 counties? Is that your message? That's the first question. And the second question, with the governor's suit that's going to the state Supreme Court to address the constitutionality issue, if the Michigan Supreme Court rules that abortion is a constitutional right, does that then make abortion legally bulletproof here in Michigan?
I'll answer your second question first. And the answer to your second question is yes. If the court should establish that, that there is the right for a woman to have and for a doctor to perform an abortion, and it's embedded in our Constitution, then certainly that would allow for abortion to continue to be legal in the state of Michigan. I mean, I would suggest, not only that the court has the opportunity to make that ruling, but that it's also still important if we want to ensure that that right is maintained, that this ballot proposal be passed into law, because then you don't have to worry about another court a few years later saying, I don't believe there's stare decisis here, and we're gonna go back and reevaluate that decision. And the way to stop that from happening is for this ballot proposal to pass. But should the Michigan Supreme Court, under the current Supreme Court, render that that opinion, then yes, abortion would continue to be, would continue to be legal in Michigan. As to whatever message I'm sending, I'm merely sending the message that my office will not be involved in any of these prosecutions. And I guess, people in those counties where the prosecutors have also indicated they're not going to prosecute, they can receive that however they like. It's probably a better question for those providers to ask what their thoughts are on that. But again, I would note, as we just talked about, the 6-year statute of limitations, I think, would be concerning because elections have consequences. And, it's not just that I'm not going to be in this office forever, and I could be in this office only another 6 months, or I could be in this office another 4.5 years, but that's it. And we don't know who's going to succeed me.
We'll go to Ben.
Thanks, Attorney General. Going back to your pledge to not be involved in these types of prosecutions, what kind of repercussions could you face for doing so? I mean, it's a foregone conclusion that the Republican legislature would likely sue you on a writ of mandamus to force you to do so if that is what you do. So, what are those repercussions, and how do you plan to defend your office should that occur?
Well, I haven't seen any such lawsuit. That's the first that I've heard of them suing the Department of Attorney General to make them defend a case. I invited the Republican legislature to be a party in this lawsuit. And if they believe that this 1931 law passed by the legislature is defensible, they can intervene. I asked them to intervene, but they have chosen not to. So it's very odd to me because the Republican legislature, since I've been in office, they ask to intervene in cases all the time, even when I'm vigorously defending the law. And I will say, even most recently, a case called Mothering Justice, even though we had erected a conflict wall in the office, and even though we had one side of the office, again, vigorously defending the law, they still asked to intervene anyway. So it's very surprising to me if they feel so strongly about the 1931 law. Come on in, Republican legislature, and you have every opportunity to defend it and defend it exactly how you think it should be defended, and to make whatever arguments you want to make in defense of this law. So it seems very odd to me that they would sue me to force me to defend this law when they could be defending it themselves.
Thanks, AG. And I just want to be clear, there's no such lawsuit. This is just an assumption based on everything that I've heard. So
Got it.
Charlie.
Oh, great. Can you hear me? I hope I do this thing right. I got 2 questions, but real quick, the first question is, often the Attorney General will bring an action based on a complaint. And in this case, the state police, I'm assuming, would bring the complaint. So are you telling the state police not to prosecute violations of Roe versus Wade? That's the first question. And then I have another one after that.
Can I answer the first one first?
Yeah.
So I am telling the state police that if they do decide to pursue investigations under which they are requesting a charge under 750.14, don't bother bringing them to my office because we're not going to authorize those. So that's up to the state police who they want to investigate. I'm just saying that my department is not going to be signing off on those, and my special agents won't be investigating those cases. So that's the answer to that question.
Okay. Second question real quick. How much political, do you think that this is going to be a big fundraising boom for Democrats to raise money, maybe saying that, listen, elect pro-choice candidates, otherwise look, it could happen. Do you think you'll cash in based on this leak of this case?
I mean, firstly, this was going to happen anyway, right? It's just we know about it maybe 6 weeks early. This was an inevitable result. You know, there are a lot of those of us that ran for office in part because of this issue. This is a very important issue to me. It's an important issue to the governor. This is a right that was enshrined into the Constitution, as far as many of us are concerned, for half a century. And it's a right that, you know, will no longer exist. It's a very odd set of circumstances. You know, generally speaking, throughout history, we gain rights. We don't normally lose them. They're not normally eviscerated the way that the Dobbs decision would do to this, again, this half-century old precedent that was set. And, you know, again, I ran for this office in part because I saw this day coming. And I knew at some point that we needed to have an attorney general that wasn't going to persecute women for a choice, a very difficult choice that should be between them and their doctors and women and their families, and not for a politician to be sitting in, you know, in their doctor's offices making that decision for them. And so I've believed that for a very long time. Whether or not, you know, it is helpful politically, honestly, on one hand, that's not why I am taking the position that I'm taking today. I've always held fast to this position. And I assume that the voters elected me in part because they knew that this was my position. I certainly made no secret of it. I mean, I made a commercial out of it, right? But here's what the message that I would send to voters. And that's that there is one party that believes in protecting women's reproductive rights. And then there is another party that wants to remove those rights and is probably celebrating this impending decision. And when people go to the polls this November, that, you know, this should be first and foremost in the minds of a lot of people, because even if you are not a woman of reproductive age, it's likely that you know one or you're related to one. So in terms of, you know, for our sisters and our daughters and our granddaughters, and in some cases our mothers, you know, these are going to be rights that no longer exist. And you never know when that is going to be, by losing this right, where it will end up that, you know, a woman will die as a result. The other thing I will say, Charlie, is this. I believe this is going to cause a substantial increase in domestic violence cases and in domestic homicides. And we've seen that in countries where abortion is illegal. And, you know, I've handled a number of domestic homicides in my time as a prosecutor, where the boyfriend or husband or the father of you know, the pregnancy wanted the woman to have an abortion, and if she refused because he did not want to pay child support or no longer wanted to be associated with her, or maybe it was a woman who was a mistress and he, you know, was married to someone else or with someone else, for a variety of reasons, decided it was just easier to kill her than to have to now be tied to this woman, especially financially tied to this woman. So I do, you know, I've cautioned, I've been going around the states and talking to different domestic violence advocates, not advocates for domestic violence, but who work as advocates for victims, and also domestic violence shelters. And I've been sort of putting them on high alert. Expect to see an escalation in domestic violence cases and in domestic homicides as a result of this ruling.
Brandon?
Thank you for your time, Attorney General. Last December, Supreme Court Judge Sodomy made a comment saying that the court would not, quote, survive the stench if, quote unquote, if the court decided to overturn Roe v. Wade. I was just curious if you could talk about how this decision could impact the reputation of the Supreme Court in the minds of everyday Americans who obviously have no decision on who gets to be in that court in the first place.
Well, I think that already, you know, the faith that we've had in the United States Supreme Court has been significantly compromised. You know, you had the fact that The Scalia nomination, Obama, that was Obama's nomination to make, but he was robbed of that by Mitch McConnell and the postponing for almost a year of the ability to fill that. I mean, he didn't, his nominee didn't even get a hearing on it. So I think that probably was